Honourable Member for St. Albert, Edmonton.
Thank you, Mr. Speaker, and I rise to speak on Bill S-215, introduced by Senator Dick and sponsored in this place by the Honourable Member for Winnipeg Centre. This bill seeks to amend Section 718.2 of the Criminal Code, whereby it would provide that where a judge is imposing a sentence for a violent offense, certain violent offenses, including murder and sexual assault, that the judge would be required to consider as an aggravating factor the fact that the victim is a woman who is Indian, Inuit, or Métis. The Honourable Member for Winnipeg Centre is a strong advocate in this place for Indigenous peoples. There is no question that the rate of victimization amongst Indigenous Canadians is disproportionate, and that is particularly so with respect to Indigenous women. Indeed, Indigenous women are 3 times more likely to be victimized than non-Indigenous women. There is no question, Mr. Speaker, that the intentions relating to this bill are good. They are good intentions. But, Mr. Speaker, good intentions do not always make good laws. And it is on that basis, Mr. Speaker, that I regretfully will be unable to support Bill S-215. There are 3 reasons why I believe that this bill, unfortunately, falls short. First, it is partially redundant. Secondly, there are serious constitutional questions about whether it would run afoul of Section 15 of the Charter, which guarantees equality before the law without discrimination. And thirdly, there are questions about whether it is inconsistent with the Gladue principle in sentencing, which is enshrined in Section 718.2 sub E of the Criminal Code. With respect to the issue of partial redundancy, the fact is that in the Criminal Code, the fact that a victim is a woman who is Indigenous is already considered to be an aggravating factor to the degree that the offense was committed on the basis that the individual victim was a female Indigenous person. The key, though, is motive, the fact that it was motivated by a prejudice or hate towards an individual on the basis of their gender or on the basis of their race. And that brings me to the second point that I raised, which is the question of whether this bill would violate Section 15 of the Charter, which guarantees that all Canadians are entitled to equal protection and equal benefit under the law without discrimination. Mr. Speaker, what this bill would do is actually quite novel in terms of the Criminal Code from the standpoint of aggravating circumstances. It is novel because it would create a special class of victim, namely Indigenous women. Now, as I mentioned, Mr. Speaker, race and gender can be considered aggravating factors, but the basis upon which that would occur was if the offense was motivated because the victim was of a certain race or a certain gender. Similarly, Mr. Speaker, there are other aggravating circumstances that relate to the connection between the offender and the victim. So, for example, if the victim was vulnerable, and many Indigenous women are vulnerable, and in vulnerable circumstances, then that could be considered an aggravating factor. My friend from Winnipeg Centre in his speech alluded to the fact that there are aggravating circumstances in the criminal code with respect to service dogs and transit workers. But there again, Mr. Speaker, those aggravating factors arise from the fact that those individuals are performing certain duties, a transit worker, for example, who is attacked. So again, Mr. Speaker, there is a connection between the offender and the victim based upon the offense at hand. By contrast, what this bill would say is that it doesn't matter whether or not the offense was motivated by the fact that the victim was an Indigenous woman. Indeed, it wouldn't even matter if the offender knew that the victim was an Indigenous woman. The fact would be that simply because the woman and Indigenous victim was that would constitute an aggravating factor. And so that is unique, it's novel, it doesn't exist in the criminal code, and many lawyers who did appear before the Senate Legal and Constitutional Affairs Committee did flag the constitutionality of the bill on that basis in respect of it running afoul of Section 15 of the Charter. And then finally, Mr. Speaker, there is the issue of the Gladue sentencing principles. The Gladue sentencing principle provides that when imposing a sentence on an Indigenous offender, that the judge is to consider all reasonable alternatives to incarceration. Now, we know that a disproportionate number of victims are Indigenous women. But at the same time, Mr. Speaker, there is regretfully an over-representation of Indigenous and primarily Indigenous male offenders. And so, on the one hand, in those cases, you have Section 718.2 sub E that says that a judge is to look at all reasonable alternatives to incarceration, but at the same time, it would be treated as an aggravating factor, the fact that the victim, which more often than not is an Indigenous woman. And so there's certainly going to be some litigation, some degree of uncertainty around sentencing. And from the standpoint of backlog and delay in our courts, which is a very real issue today, Mr. Speaker, that is problematic. So, Mr. Speaker, while this bill is a well-intentioned bill, while there is no question that Indigenous women are disproportionately victimized in this country, and while there is no question about the fact that we, as members of Parliament of this place, have a duty to do what is necessary and to bring about necessary changes to protect vulnerable persons, including Indigenous women, this bill misses the mark for the aforementioned three reasons that I enunciated. Thank you, Mr. Speaker.